Managing finances after death. What are the executor or administrator's main duties? Dealing with the death of a loved one is stressful enough, but not knowing what to do with someone's finances after the person has passed away poses an additional burden on a grieving family. When someone dies, the executor, if there is a will, or administrator, if there isn't a will, normally sorts out the finances and then distributes what's left according to the will or the laws of intestacy. In some cases, an executor or administrator may not be needed. If you're acting as executor or administrator, it's advisable to speak to the deceased solicitor and accountant if they had one. Whether or not you get help from a solicitor, to be able to deal with the deceased's affairs and access funds, you'll normally need to apply to the probate registry for a grant of probate, or letters of administration. You have 1 year from the date of the deceased's death to sort out the estate before distributing it. After a year, you could become liable to pay interest on any undistributed assets. It's worth bearing in mind that all bills, debts and taxes have to be settled before you can share out the deceased's remaining money, property and possessions. Some of the documents you will need to find belonging to the deceased include tax and national insurance affairs, bank, building society and savings accounts, and certificates, stocks and shares, state and private pensions, state benefits, car, health, home and life insurance policies, utility bills, other unpaid bills, property deeds, mortgage payments, rent payments, credit card and store card payments, loan payments and other formal debts. If the deceased was self-employed or a business partner, you will also need to collect together any documents relating to the business. It is usually the case that only the executor or administrator will have access to the deceased's money, and you will need various documents to do this. However, there are some exceptions. Some estates have to pay inheritance tax. Some or all of this must be paid before the court will issue a grant of probate of letters of administration. The deceased may also be owed a tax rebate, or may have to pay some tax. If you sell the deceased's property or other assets at a gain, profit, capital gains tax (CGT) will be payable if the gain above the market value at the date of death, not the date of acquisition, exceeds the current CGT threshold. Other payments you may have to make include rent or mortgage on the deceased's home, funeral costs, any outstanding bills, formal debts owed by the deceased, insurance on the deceased's home, other payments to protect the estate assets. Money owed to a deceased is part of their estate. You may be able to claim tax rebates, life insurance, money from pension schemes, money from lost or forgotten pensions and savings, capital from the deceased's business, formal debts owing to them. However, any informal loans made by the deceased don't have to be repaid by the borrower. It's good to talk. To arrange an appointment or to discuss any concerns that you may have in relation to making appropriate protection for you, your loved ones and your estate, please contact us. We look forward to hearing from you. Smith Equity and Trusts 020-7193-0946